and ULS Punjab University Chandigarh. We welcome you all to yet another enriching and engaging session on Constitution and Constitutionalism by Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India. He is known for his judgments as a judge of the High Court, Chief Justice, and the judge while being a judge of the Supreme Court of India. He has delivered more than 900 judgments while being in the Supreme Court. Those judgments are path-breaking in itself. They laid down a different trajectory of law which will be followed for all times to come. Justice A.K. Sikri is known for his humility and his command over the subject while he was penning down the judgments. It was always a pleasure for any lawyer to appear before him and argue a matter. The amount of ease which one got while appearing before him speaks volume about that, and he has always been connected with the educational institutions and universities. And the fact that he has joined us and ULS Punjab University Chandigarh. ULS Punjab University Chandigarh has created its benchmark within a short period of 16 years. For every student of law, it is one of the dreams to join an institution. It is rubbing its shoulders with one of the best institutions in law. I would call upon Professor Ratan Singh to introduce ULS to the participants, because we are having participants not only from Pan-India, but also from different countries. Over to you, Professor Ratan Singh.
Thank you, Vikas ji. Just see about University Institute of Legal Studies. It was established just in 2004. And in a period of just 16 years, as even yesterday I told that we have brought the laurels for the Punjab University. Reason being, in such a short span, and the institution which is a very young institute, we have a reputation as well as at national level and at international level too, because our students, our faculty, they're so dedicated as far as the research is concerned or as far as the practice is concerned. Many of our students are settled on in probably all the high courts. They're good in practice, they're good in their profession. They have joined corporate sectors too also, and many of the students, they have joined the teaching profession too also. So probably wherever I go, and if I ask about the ULS, and I think there is not a single institution which is not aware about the University Institute of Legal Studies, and that for this we are very proud.
So sorry to bother you, Professor. Yeah. Justice A.K. Sikri has joined with us.
Yeah, sure, please. Let's start.
Yeah. Yes, sir. So Justice Sikri, as I was saying, that he's an institution within himself. His judgment of Aadhaar is well known. And I dedicate the opening lines of the Aadhaar judgment itself to him, wherein Justice Sikri had said, it's not important to be number one, but it is important to be unique. Because when you are unique, you are the only one. And I can surely say on behalf of BeyondLawCLC as well as ULS, that in fact, he was number one, he is number one, and he's also unique. Therefore, he's a combination of being number one as well as being unique. Over to you, Professor Ratan Singh. Thank you.
Sir, on behalf of CLC and University Institute of Legal Studies, Punjab University, I welcome you here on this platform, listening to you about Constitution and constitutionalism. Dear friends, let me to introduce Justice Arjan Kumar Sikri. That he was born on 7th of March 1954, and he did his law from Delhi University. And after a good practice in Delhi High Court, he joined the bench of Delhi High Court, and then he made as Chief Justice of Punjab and Haryana High Court. And then he was elevated to the Supreme Court on 12th of April 2013. And he retired from the Supreme Court on 6th of March 2019. And after that, he is appointed as an international judge of the Singapore International Commercial Court. Friends, during the span as a Chief Justice of Punjab and Haryana High Court As a judge in the Supreme Court, he has a bundle of judgments which has given a shape to the jurisprudence. And talking over about his pronouncements and about his judgments, once he said, it was not about how many times a judge smiled, but how many times the judge has brought a smile to the helpless people. So meaning thereby he is a judge of the helpless people, and the judgments which he has delivered has totally given a total shape to the humans. Because reason being, he believe in we rather than I. And while in his judgments, he always say the constitution is to be interpreted in a very dynamic way. And while interpreting the constitution in a very dynamic way, he has elaborated about constitutional morality, and he has given the shape to the living constitution. So at the end of this, I say he was not a judge for the lawyers, but he was a professor judge, and for students, for the lawyers, for the judges, because he teach wherever he is. Thank you very much, sir, and welcome again on this platform.
Thank you. I can start?
Yes, sir.
Yes, good evening to all of you. Some of you I can see on the screen, and all the other students and lawyers who are there and listening to me today. I say at the outset that because of this COVID-19 situation, we are in isolation, maintaining social distancing, etc. And the situation is really grim, at least as of today. So in this whole scenario, greetings to you and wishes that you remain safe in your houses. And I hope that like all other crises, humanity will be able to overcome this crisis as well. As it is said, this shall also pass. I am thankful to the organizers today, this university, as well as Mr. Chattat's organization, which has arranged this program. I really admire that these times when we are all confined to our houses, at least there are some who are trying to have the best of it in whatever possible manner. And one thing is that, yes, at least learning from each other through these webinars, insofar as legal community is concerned. Coming to the topic of the day, which is assigned to me, Constitution and Constitutionalism. This talks of two, it uses two expressions. One is Constitution and other is Constitutionalism. Yes, we have all heard about what the Constitution is, or at least we have heard the name Constitution. And but that what the Constitutionalism is, that may be, or that would be the fulcrum of my talk today, in the context of course, the constitutions. But what I was thinking, look, as of today, we know, and we are all products of, I call it independent India after 1947. Most of us who are there, I think, should be, they are born post-independence, in post-independence era. And when we grew, we knew that, yes, there is one constitution of India, which is the highest law of the land. And since all of us are law students, that means we have studied law. So we have studied the nuances of this, various provisions of this constitution as well. So therefore, we know what constitution is in that sense. At least we have the feeling, we have the flavor of what constitution is. But in this whole scenario, I thought that as I'm described as a professor judge, so why not talk like a teacher in a class? Of course, I would be sharing my views and will be. Hello, whether I'm audible?
You would have to slightly come nearer to the mic.
No,
so some people are saying you are.
No, mic I can come nearer, but the video is gone actually.
So I'm trying that. I'm just trying.
Okay. I can see you, Mr. Chattat, now, but
No, sir, somebody has shared a screen. We are trying to disable that.
Okay.
Give the rights of hosting to Sapan.
Okay. Anyway, in the meantime, yes, it has come.
Yes, sir.
So I was thinking, why not let us start and at least give some background, not in very detailed form because that we don't have that much time, but some background of how these constitutions have emerged in this today's world, because most of the countries today are democratic countries and governed by the constitutions. There may be in some countries, including, like we know, England and Brazil, sorry, not Brazil, Israel. We have unwritten constitutions, but still they have some principles of constitutions which are practiced there as well. But then how is this all this idea arose in a mankind? Because constitution, if I say in the beginning, it's an instrument of governance, which how the country would be governed. And the country, like India, we call it America, we call it Israel, we call it UK. These are all nation states. So we have more than 200 nation states in the world today. So, but then going back to some history, and that would be very relevant for the purpose of understanding at least the constitutionalism, how these states originated. If we, I'm not, if we see the history, you see about 10,000 years ago, the humankind started agriculture society based on agriculture. Before that, for millions of years, humans were nomads. They were going from one place to other. They didn't have fixed abode or fixed place. They would normally be hunting, or from the jungles, etc., trees. If there are fruits, etc., they will be taking either. So therefore, on hunting and with these from the nature, whatever the produces are, they will take that, and but they will go from one place to other. Of course, in those era, we can't think of any nation state at all. But even when the agriculture system started out of almost 10,000 years ago, because if you see, the mankind first millions of years ago, then 10,000 years, and the industrialization which starts, or the states which started coming up hardly few hundred years, and democracies, when I come to that. But then in this agriculture society also, there were no nation states. Maybe people, they started inhabiting at a particular place in groups, normally near the rivers, because it was easy for them to do this activity of agriculture. But then in those times also, which was when they were nomads as well, there were no, maybe in loose form some societies, but then how they have to live in an orderly manner, that was not there. So therefore, in our language, we call it Jungle Raj, or we call it might is right. Those were the, situations, or those were the conditions. And here now I am coming to what Thomas Hobbes, because I start with that. Thomas Hobbes described it as a social contract, which the people arrived at in these circumstances. So he, in his book, the name of the book is Leviathan. So he, in his book, he says that, look, what is this condition when there is no security, there is no organized society which is governed by rules, etc. Then it is, two things which he says. There would be a situation of insecurity, and there would be a situation of dominance. Insecurity means I will feel insecure. Tomorrow somebody may come and kill me, or he may take things, or he may snatch things from me. I may have done my, agriculture produce. Some mighty man comes who is in the neighbor, he's physically more mighty. As I said, might is right. And if that is a situation, and his dominance would prevail over me, and he could take away from me the things, even the fruits of my labor, etc. So therefore, in this situation, he calls it that there were no rules, and there was a continual fear and danger of violent death. This he calls the situation of warre. It's not war word used, WARRE, warre, situation of warre, which another political scientist later called this as anarchy, if we understand the anarchy very well. So he calls it anarchy. And then in this situation, what he says is that, look, you see, there is, as I said, insecurity, there is a dominance, and at the same time, we know the psyche, basic psyche of the people. They want to live in peace. Most of the people want to live in peace. And they want that they should not be insecure. So therefore, he says that, look, how to overcome this situation of warre into a situation where the society is governed. Now here, in a situation of warre, as I said, there's a fear from everybody, there's an insecurity, but then this is because we are not organized. So he says that, he describes that, as I said, the book name is Leviathan. He describes Leviathan as a state. And he says that, look, if the people come together, and that is where the social contract comes. They come together, enter into a contract between themselves, all the people, that, look, instead of having the system of this kind, why not we give this authority to one person who is able to govern all? We all will give that authority to that person. So therefore, instead of everybody exercising his jurisdiction or her jurisdiction, here it is given to some persons, and this is the contract which we enter into. It is social contract, and therefore he calls it this he calls as a Leviathan. Actually, Leviathan is he has used this expression or this word from the Bible, where it is described in the Bible as such. And on that basis, he says, and he calls it in the Bible's book of Job. That is the name of the book, Bible's book of Job, where it is better to have authority in one person. I'll come to the limitation of this, or the weaknesses of this theory, and how it is improved, and we have come to the present state. But it still remains very, very relevant even today when we talk of today's constitutions and constitutionalism. So he calls this state with this kind of, it is created a Leviathan or a Commonwealth. Commonwealth all join, not Commonwealth in the sense that UK, when the England ruled most of the countries, and all those countries are even today called Commonwealth. So in that sense, that was the Commonwealth of the UK. Here it is a Commonwealth of the people, or we call it nation state. So you may call it Commonwealth, you may call it state, nation state, or you may call it Leviathan, as he called it. Now, he said that, look, there are two ways in which this state can be created. One is by acquisition. That is, somebody comes, some who is very superior, very authoritative, he may have some backing of people, and he acquires it. It can be, therefore, it can assume the form of dictatorship. It can assume the form of which our history has seen. We have seen dictatorships also, and assume the form of monarchy as well, where kings rule. So this acquisition is also a Leviathan state. He says it is still better that there is one person who is ruling others, instead of every day everybody is in a state of unruly state, where dominance prevails of anybody and everybody. But the second system, where the social contract theory comes, is where the people, they choose who should be the person, and we give him the authority. This, he says, is where the Leviathan is created by institution. So some institution is chosen, and the people have chosen that institution, and that institution will govern them. They have given that institution an authority, which in today's word, we say that we choose by elections, we choose our representatives, and we elect them, like in our parliamentary system. If I'm giving, just to make it understand what he meant, today we elect them. So there are political parties who contest the election, and a group or a political party which gets the majority, that party becomes the representative, chosen representative of the people, and therefore right to govern. Now, this is, if you see, social contract theory is the basis or is the foundation of this democracy which we call today, where the people elect their representatives, and in the process they they give that person authority. But as far as Hobbes is concerned, he stopped at that. He did not think, he thought of an institution, but he thought of one authority. And as I said, he said that, look, that one authority can also dominate to whom we give the power, but it is better if one person or one authority dominates rather than everybody every day dominating the other. So this is what his total idea was of the social contract theory with a single face. Now, what was thought over a period of time, that look, so one thing which I should tell you, this social contract theory, and which is the concept which is valid even today, is based on liberty, because people cherish their liberty. They want to live the life the way they want, so that they have a freedom. And that is why, so it should not be interfered with by my neighbor who is mightier than me, or anybody who comes. So I am giving authority to some person or elected representatives, as I say. So this is the social contract which we have entered into. The persons have, all the people in the country have entered into that contract, giving the authority to that particular person. Now, what was thought by later political scientists was that, look, there's one thing which is lacking in this, that why, if there is social contract theory and it is based on liberty, and then why we should have a situation where even the persons who are elected, or the institution which is created, I'm talking of in Leviathan, in the what was the perception of Thomas Hobbes, why they have the right to then dominate and misuse and abuse that power and dominate in a wrong sense. So therefore, over a period of time, there have been modification of that theories from time to time. And the most important modification was based on this, that look, if we have given the authority to a person to govern, this should be limited authority. And therefore, from there arose the concept of limited government. That is, the government which we choose, the government which we appoint and elect, has a right to govern, but at the same time, this right should be shackled by some norms, by some system, so that the power is not misused. And so from here, we come to the concept of, actually, in a way, that what are these norms and how the society should be governed. Over a period of time, because for want of time, I can't give the, so many political theorists who have developed, and what was the, I just told in a very brief manner what was the shortcomings of that Leviathan and how these are improved, and without naming all those political theorists. So here, when we talk of norms, we talk of some principles, we talk of some rules and regulations under which the elected person should also is in a position to act. Here we come, what is that instrument? So people think that that instrument should also be given by us, on the basis of which it works. And that is what the Constitution is. If you see the word Constitution here, when I come, is, and I'm talking of a democratic constitution. I'll come to that when I come to constitutionalism. Constitution doesn't mean that it is necessarily in a democratic constitution. If in loose form, there can be, if you are a member of club, there can be a constitution of that club, how this club is to be governed. So there may be another society, there may be constitution of that society. So when we talk of constitution of a nation, so we talk of the highest law of the land. That is what the perception is, and rightly so, which governs the that nation, that state nation, which creates the institution of governance. So another thing which I said, Hobbes talk of one institution. In order to see that there is no misuse of powers, etc., over a period of time, the improvement which was made, that no, number one institution may not be able to discharge all kinds of functions. Maybe monarchs or the kings were doing that, but no, today we need more than one institutions. So in modern constitutions, therefore, normally three institutions are. One is our elected representatives, which is the legislature. They are elected. Second is the executive, that is the majority party which assumes the power and makes the government. So that is the government or the executive. And third is the judicial. I'll tell you the relevance of all this when I come to constitutionalism. So therefore, in these scheme of things, power is not given to one institution. Legislature is supposed to make laws. Executive is supposed to execute those laws and by making policies, etc. And judiciary is supposed to decide the disputes or interpret those laws or enforce those laws, as we say. And the system is based again on checks and balances. One that would be a principle of constitutionalism when I come to that. Now, question is this, that look what happens. The constitutions, as I said, could be of various kinds, and these constitutions not necessarily are the constitution. I have talked to you about a constitution of a democracy, but then somebody has said that there can be 6 or 7 types of constitutions. One is, I have explained, written or unwritten. That is one thing. Other is federal or unitary, that we should have federal system, or unitary, that is a system of governance. That like our constitution is federal, UK constitution is although unwritten, unitary. Then whether it should be, even the constitution can be separated powers or fused powers. I have said that the three the institutions or the 3 pillars of the state, legislature, judiciary, and the executive. So our system is based on separation of powers. But then there may be constitution at some places, in some countries, they may have that system where there's a fusion of these powers, that they exercise the powers which may belong to one or other also at given times. Now, apart from this, these may be on the basis of which the system is there, which may be prevalent. So parliamentary democracy, which is in India and UK, or presidential democracy, which is in US. So these may be systems, various systems. But at the same time, even the constitution can be rigid and flexible. Rigid means what is given and what is stated there is not going to change. Flexible is when you may change it from time to time. Or it may be supreme and subordinate also. That the constitution, like in our country, constitution is supreme, but in some countries it may be subordinate. It is subordinate to the king. It is subordinate to, like monarch, it is subordinate to some dictator there. So, and another thing which is that it may be, constitution may be republican, like we are a republic, India, and constitution can be in monarch system also. King is there, but he has framed a constitution. And so the question that arises is that in which form of constitution we have a democracy, and what kind of democracy we are talking about. So that becomes important in our polity. And here, of course, we have talked of democracy, and in the process we are talking of this sorry, we are talking of democracy, and one democracy and simple form of democracy, if we say, where the people are electing their representative based on social contract. But whether, and majority rule, in a majority rules, and majority has the right to rule. But that is treated as only a formal aspect of democracy. But democracy is not only that. in any good system, the democracy is not only to be formal, it has to be substantive or liberal democracy. So which is very, very important. And therefore, what is in the first form, we say many times, since the people are electing, like our constitution also, which is given in Indian context, if you all know, it starts with the word we the people. So we the people have enacted, and we the people, of course it was a constituent assembly, but constituent assembly was working on behalf of the people of India, and people of India gave this constitution to themselves, how the country would be governed in future. So that is a democratic society, democratic way of doing it, and in which we call that the people are the sovereign, and since they have given. Of course, sovereignty attaches to the nation also, in the sense, once the constitution is given, and that is said that India is a sovereign country, because that India has to have its own power vis-a-vis other countries. So we are a sovereign power, we have a right to exercise that power as a state. So sovereignty is with people, sovereignty some state is given, and that is why once the sovereignty is given to the state, state has the right to not only make those laws by imposing law and order situations, by curbing the crimes, etc., but also as a sovereign state to take care of any war by the other country and aggression, etc., to defend that, or to even wage war against the other country. So in that sense, sovereignty is given to that state also, or to the elected people as well. But I'll come ultimately, when I come to constitutionalism, that what is the concept of constitutional, where the sovereignty arises. But then this, as I said, is the formal aspect of the democracy. But what is the liberal aspect, or what is substantive democracy? In a substantive democracy, it is not only that the majority rules. It is that majority, if the majority has come to power, that doesn't mean that they have a right to crush the minority. Here I'm talking of the minority, the persons who are in the parliamentary system in minority, maybe we call it opposition, or even minorities in a particular, the ethnic or other minorities also. So therefore, they also have their right. As I said, social contract theory, I come back again, is based on liberty. So therefore, in a liberal democracy, the constitution will imbibe all those principles which we call it are based on separation of powers, that the three wings have the separation of powers. They are based on rule of law, judicial independence, more importantly, human rights, and the other values of morality and justice, etc. So all these values have to be there to make it a substantive or real democracy, and not that once a particular party is elected, they have then right to rule in whatever way they want. So that is what we normally call a democracy to be a substantive democracy. And now coming from there, and once we have understood, and if you see, I will say in very brief, the most of these features are there in the Indian Constitution. We have the democratic system of elections, and the again in a liberal democracy, elections have to be free and fair. Now elections can be in a communist country also, but in a communist country, communist party says, these are my candidates, A and B. You have a right to elect, you elect A or B, but then nobody has right to contest. That is the political party or communist party which is fielding its own candidates, and you are given a choice whether you go to A or you go to B. And so it is not that form where everybody has a right, and free and this fair elections are there. But then we have that system in our country. We have human rights. We have the system of fundamental rights. We have the three institutions, the roles of all the three institutions, as I described, are stated there, and they are based on the principle of separation of power, that it is not based on fusion. That means everybody has to discharge its own function and not to trample upon the function of the other. And we also have some other constitutional institutions like Election Commission, UPSC, etc., to take care of what we call good governance in the society. But the question is, this may be democratic or liberal democracy, we call it, but then how we ensure this liberal democracy. To ensure this liberal democracy, we have the principles of we come to the principles of constitutionalism in a constitution. This one author, Barnett, in his book Constitutional and Administrative Law, he describes the concept of constitutionalism, and I'll read 2 or 3 lines from there and then I'll develop on that. He says, constitutionalism is a doctrine which governs the legitimacy of government action. By constitutionalism is meant, in relation to constitutions, written and unwritten, conformity with the broad philosophical values within a state. And I have told you those values, human rights, etc., other things. And he says constitutionalism implies something far more important than the idea of legality. That is the formal democracy, as said, legality, which requires official to conduct be in accordance with the prefixed rules. He suggests 4 kinds in this process. First, that the exercise of power be within the legal limits conferred by the Constitution. That means every institution exercises the power within that. If you know, legislature today in our Constitution, we have a federal constitution where the parliament is there, where that is central legislation, where the state legislature is there in each state. But then who can legislate? Power to legislate is there, but that is again limited or given by the constitution in 7th schedule, entry list 1, list 2 and list 3. List 1 enumerates all those subjects on which the parliament can legislate. So state legislature cannot legislate. Now list 2 gives all those subjects on which state legislature can legislate, on which parliament cannot legislate. Then we have 3rd list, which is concurrent list, where both can legislate, but then how to have the repugnancy removed, etc. All those article 246, 245, etc. Those are given, and those situations are also taken care of. And it is so therefore even the 3 institutions are supposed to act within those limits which are there. And the second thing he says, the exercise of power, irrespective of legal authority, must conform to the notion of respect for individual and the individual citizens' rights. Here comes the importance of human rights or the fundamental rights. You are exercising those powers. Legislature can exercise the power. Now parliament, as I've said, can make the law as per subject list in list 1, but no law can be made which offends the human right of any individual. So therefore any law which is made which offends principle of equality enshrined in Article 14, freedoms given in Article 19, or Article 21, that is it offends right to life and liberty, or for that matter any provision of the Constitution, such a law is invalid. So even the parliament has no right to make a law, because such a law will be treated as unconstitutional, and because it is offending the fundamental right, one or the other right of individual or the body of individuals. Third thing which he says, that the powers conferred on institutions within the state, whether legislative, executive or judicial, be sufficiently dispersed between the various institutions so as to avoid the abuse of power, which I have told you, separation of powers. Fourth, he says that the government is formulating policy and the legislature is legitimizing that policy by making law, is accountable to the electorate on whose trust power is held, because they are doing so all after they have been elected by the people. And that is the reason that the elections, it's not months, elections take place after every term. Here in India we have 5 years term, there may be 4 years, like in US president it is 4-year term. So after 5 years the elected government has to go back, all the persons have to go back to the people whether they want to elect them again or not. And it is because, and in that sense it is accountability of the electorate representatives. Now what are those then, the question comes, and the important question comes is, what are those precepts of constitutionalism which ensure all this? I have actually in a way given a hint. If you see, number 1, as I've said, which are very, very important, is that the power is not in one institution, it is in 3 institutions, which is based on again separation of powers and checks and balances. Separation of powers, as I said, there different powers are assigned. Now these are, I'm now talking the principles of constitutionalism. So first is separation of powers and how and balances. It's a very important thing. Each branch is able to check the other. That within the constitutional scheme that is provided. Now law is made or executive action is taken to execute the law. If that is unconstitutional or against any law, then judiciary is there to write that, to set it right. On a power of judicial review is given to the Indian courts, constitutional courts, and the power of judicial review is not limited to the executive action, but even the legislative action. And law can also be declared unconstitutional. So this is the power which is in India and in the US and in some other countries, which is not in all countries. Such a power is not given. In some countries, like even in UK, in a way, Parliament is supreme because the law made by the Parliament cannot be questioned in the court of law. Before, the courts have no power to strike down the law. That is why it was said at one point of time, I remember when I was a student, that the British Parliament has right to legislate on every subject and everything except making man a woman and woman a man. So they can do anything. But then I say today jokingly that now even that is possible because the medical science has advanced so much that man can be made woman and woman can also be made man. Anyway, that is aside. But then, in Indian constitution and the liberal democracies, this power is given. Likewise, a particular judgment is given by the judge or by the court, which the legislature feels is not in accordance with what they legislated because the court is interpreting. So legislature has right to amend the law and bring it in tune and set at naught the effect of that judgment of the court. So this is the system based on checks and balances where the judiciary has erred. It can be corrected by the Parliament also. Now that is the first principle. Second is, which goes along with this and on which I'll come later, but it is very, very important, is when the judiciary is given this power and judicial power, independence of judiciary is also maintained. Because unless the judiciary is independent, the judiciary is not an independent, and as we call the expression we use, judiciary should be not only independent but fearless also. That means howsoever strong may be the government at the center, they may have won 400 seats out of 540, or they may have won 440 seats and they have hardly any opposition. But then the judiciary has to be very, very strong and it has to be independent. Only then it will be able to check the misuse of power by the elected government by means of judicial review. So therefore, independence of judiciary becomes a paramount ingredient of a constitutionalism. And the other is, as I already told you, this is human rights. In any such constitution, that the constitutionalism is not there if the human rights of the people are not respected. And these rights we call, although they are stated in the constitution, most of these rights are natural rights, which were there, and the Supreme Court has also said from time to time that many of these rights were there even when the constitution was not there, because these are natural rights. And other very important feature is minority, protection of the minority. So minorities protection in any so if you see what were the attributes of a liberal democracy becomes the attribute of constitutionalism in that sense. But then question here arises is, all these lead to, okay, before that question I'll come to, all these lead to what we call to check the misuse and abuse of the power. And as if you remember, I used the expression earlier, it's based on social contract. We have given the people, we have chosen that people who can govern us, but that doesn't mean they should snatch our liberty in the process. So this all calls for what we call limited government, concept of limited government, where the government's power should not be, limitless. And all these aspects ensure limited governments. But then the another question is, and the very important thing is, whether in today's days, and that was also not conceived by Thomas Hobbes at that time, whether it is only governance of this nature or limited governance. Answer is no. These are based on, and these are called, these attributes which I have told you are called the attributes of a negative constitutionalism, in order to see, or in order to check the misuse of power of the elected people. But we have the aspects of positive constitutionalism also, because our constitution does not only say that these rights are there and these separation of powers, etc. are there. If you know the Constituent Assembly debates and even the provisions of the Constitution, we have thought of a welfare state. We have thought of a state where, as Pandit Jawaharlal Nehru also said, that we want of a state where tears of each and every persons are wiped off and every person is able to get, as we call it, roti kapda makan. So it is for the, when we have a social context.
I'm sorry to bother you. Sapan, somebody is just sending the messages. Just remove him from the group. Sapan, remove him from the group. Yes, sir.
Okay. So therefore, then we have what we call the, and it is the latest theory in last 40-50 years, and particularly after Second World War, that not only we talk of liberty of the people, but we talk of the welfare of the people also. Here it is social welfare, we talk of solidarity, we talk of economic equality, we talk of social justice. If you know, these are the phrases used in our constitution as well. So therefore, these are called positive aspects of a constitution, but attributes of constitutionalism. So both the things are required. We have to have negative attributes of constitutionalism, which I said earlier, to check the misuse and abuse of the power. We have to have the positive aspects which lead to what we call good governance. That we want a government which is able to give us good governance, so that we lead towards prosperity, whether it is economic prosperity, whether it is social justice, that is equalitarian state which is there, where the gap between the rich and poor is less, and we are able to uplift more and more persons from the state of poverty, etc. And we become also, like others, a developed economy and a nation which we are talking of when we talk of 5 trillion economy today, and we are today fifth largest or fourth largest. We want to be third largest economy in next year. So all this, and for the welfare of the people, when we talk of so many welfare schemes which come out by the government, and in today COVID-19 you are seeing how for poor persons, not only the government is trying to do, government is asking people also to contribute towards that. These are all positive aspects of constitutionalism. But in a constitutionalism, both the things have to be there, negative as well as positive aspects. So that is what the constitutionalism is. But here, more important thing which comes between the two, negative aspects and positive aspects of constitutionalism, there is one between the two sets of constitutionalism. In order to achieve that, and although I have not used that expression so far, but I have hinted on that, and that is the message which is given, comes an important how to achieve that. That is what we call rule of law. So rule of law is another attribute of a constitutionalism, which is a part both of, or it sits between positive and negative constitutionalism, that the society is to be governed by rule of law. That means rule of law, it is the not law by men, coming to same thing. It is the law which would rule. As it is said, howsoever high you may be, law is higher than you. And whether it is the prime minister of the country, or it is a peon, or a maid in the house, both are equal in the eyes of law. That is what we call it, rule of law. And rule of law, again, we have both. I need not go into detail in the concept of rule of law. We have both this formal aspect of rule of law and the substantive aspect of rule of law. Rule of law means, yes, law should be there to rule, but then suppose in a country where although it is a constitutionally governed, and we have the example of our neighboring country, where in last 50 or 70 years, there are 6 constitutions have come, one after other, and the military is able to dominate in real practice, and where they may make, or any other country, suppose a law is made, but law is totally obnoxious. Suppose law is made that anybody who commits theft will be hanged publicly and publicly shot. This is again, that means, yes, law is there, and if it is done, the country is governed by rule of law. But when we talk of rule of law, do we mean this kind of rule of law? As you know, Dicey has explained what is the meaning of rule of law. Let me tell you one thing, because I am trying to concise, it's 1 hour time which is given to me. Otherwise, whether we talk of separation of powers, whether we talk of independence of judiciary, whether we talk of human rights, whether we talk of minority rights, whether we talk of substantive and the formal democracy, whether we talk of substantive and formal rule of law, on each subject there can be a detailed discussion for 1 hour each. But that is not the time doesn't permit. So therefore, I'm only conceptually defining all these things. And so coming back to rule of law, so substantive rule of law means, along with this rule of law, there is, as Lon Fuller has said, inner morality of law. That there should be inner, and how the Supreme Court, I'll come to in the last phase, how Supreme Court has tried to interpret the laws, and Supreme Court has even tried to set aside those laws which shocks the conscience and manifest arbitrariness, which depict manifest arbitrariness. That is the expression used. So therefore, rule of law again does not mean it has to be any law. We keep in mind the substantive rule of law. So these are all the aspects of the constitutionalism. Important thing which I said, another thing which is so important is independence of judiciary and the power of judicial. Now, how that becomes very, very important in the constitutional setup as a important attribute of constitutionalism. We have talked of all this, and as I told you, this is in our constitution. Such provisions are there in many other constitutions. First, we were discussing or distinguishing between a constitution of a liberal democracy versus constitution of a monarch, constitution of a dictator, etc. So therefore, in order to have a liberal democratic constitution, these attributes are necessary. But the question is, and the very, very fundamental question is, even in spite of these provision and these constitution, is there guarantee that the elected government will not misuse, that the elected government misuse its powers, that the elected government will work in accordance with the framework of the constitution? History has shown no, not necessary. It should happen, but at times it may not happen. If you know, Hitler was elected under a constitution in Germany at that time, but he became dictator after his election. Likewise, Mussolini in Italy, and all this led to Second World War. We have, not to that extent, but in if you remember, in 1975, emergency was declared. Indira Gandhi was also elected prime minister at that time, but after his election was set aside, then and a declaration of emergency is what? There is a provision of emergency in the constitution itself. So you see, she used that tool, imposed emergency, and took away all the rights, fundamental rights of the people. And of course, at that time, and when I come to the role of Supreme Court, that even the Supreme Court failed in giving that judgment in ADM Jabalpur. But that is aspect which I'll deal in detail later. But what I'm trying to say here is that in spite of this, there may be possibility that the democratically elected government, which are governed by the constitution, may also fail us, may take away our liberty. How to save that and protect that. Here comes, as I said earlier also, most important feature of constitutionalism is independence of judiciary, and not only fearless judiciary, and which has the power of judicial review. Of course, insofar as power of judicial review is concerned, it is given by the Constitution. That power is there in Indian Constitution. But exercise of that power, the manner in which the judiciary at a particular time, and it should become independent and should remain independent, that lies on this responsibility lies on the people who are the judges and who man that judiciary at a given point of time. So, but how I will now only say in this whole process, therefore, when the judiciary becomes the guardian of the custodian of the Constitution, before that, let me say one thing: even judiciary, bound by the provisions of the Constitution, and it has to act within the framework of the Constitution. So we talked of sovereignty when people elect and ultimately people are sovereign. We talked of sovereignty when the elected person or the nation state becomes sovereign because it has to exercise those powers, which is very, very important. It should not be misuse of those powers, or giving of power is important for governance. There is no doubt about it. But ultimately, when we say all have to subscribe to the Constitution, then it is the Constitution which is sovereign. And we talk of constitutional sovereignty in that sense. Now, how this constitutional sovereignty can be protected? As I say, I have said in few articles and few judgments also, I have reflected that. And it is not, I would claim that my, original thinking. This has been said by many other judges in other jurisdictions also, that the two fundamental functions, of course, judiciary is there to decide the disputes. Disputes come before the court. Two persons are litigating. It may be a family dispute, it may be a property dispute, it may be a partnership dispute, it may be IBC case or any other case. It may be a constitutional matter as well. But we are talking of constitutionalism today. In the context of constitutionalism, two main functions of the judiciary are: number one, to protect the democracy and rule of law. To protect I will add, to protect the constitution, democracy, or constitutional democracy and rule of law. That function now becomes that of the judiciary, because judiciary is the final arbiter to decide whether the action of the executive or the action of the legislature is right or wrong. Final say is with the judiciary. And if any time any law is passed which is violating the human rights of a person, now in today's context, although I need not go into detail, but discussions are there. Right or wrong, again, I'm not going to. Whether rights of minorities are protected, whether freedom of, and we are talking of freedom of speech today, the contours, that whether freedom of speech means that if I say something, if we criticize the government or the government actions, whether it amounts to sedition, all those issues are arising, and which arise whenever there is a strong government. Whether the government is acting within its power or outside its power is ultimately for the judiciary to decide. So therefore, all these actions which are taken by the government are coming for the judiciary. So ultimately, it is the judiciary which has to. And because various aspects are there, but how much time I have, so I will be able to.
So it's fine. You can continue. We can dispense with the Q&A because this is more enlightening and more engaging than
no. Otherwise, I'll say how this is, which are the various mechanism or various principles evolved by the Indian Supreme Court from time to time to ensure that the constitutionalism is adhered to. So I'm coming to that because depending on time, then I'll have to explain those.
Time is all lost. Rather, I will say
I'll have to then explain those concepts accordingly.
So only 1 minute. Sapan, just disable the chat because we will not put the question answers because some people are just not maintaining the decency as is called for. I will call upon Mr. Sikri that he can continue with the entire topic.
I can't find any switch tool.
No, just go to the participants and there you have you can do the disability. You can disable the chat also. Meanwhile, you can remove the persons who are just posting the messages which are irrelevant.
I am
Right, sir?
Okay, we can't help it, Mr. Chattar. We have all kinds of people that
No,
understand that.
right to freedom, that is the way we live.
Okay. Now, you see, first thing here I come, we have in the Constitution Article 368 also, which is the article relating to amending powers to the Parliament to amend the Constitution itself. Now, question arises, there may be a situation, and which happened at that time during emergency, when the 42nd Amendment was passed, that by making that amendment, you want to take away certain things which are the fundamentals of the constitutionalism. So here, in order to ensure that liberal democracy is protected, in order to ensure that all these provisions of the constitutionalism are protected, that is my now reading, the first important judgment which was given by the Supreme Court was Keshwananda Bharati case. Of course, in Keshwananda Bharati case, it has used the expression basic features of the Constitution. So the Supreme Court says there are certain basic features of the Constitution which are unamendable. Even the Parliament today has no power to amend, which says democracy, India as republic, independence of judiciary, separation of powers. All these are attributes of constitutionalism, which I have said. And all these are stated to be unamendable, terming it as basic features of the Constitution. Because if these are amended, now today you cannot say, you can't amend Article 21 to say that whenever government wants, and it can kill anybody in the interest of the state. That's the only, and it is whatever, I mean, whenever government thinks that X is doing something, the final decision of the government is, the decision of the government is final, and it has right to kill, and that will not be questioned in any court of law. This is killing the democracy, the very democratic principle. This is, we go back to social contract theory. I'm going back again and again, which has the concept of liberty, which founded on liberty. This is taking away that fundamental of social contract, because of which we gave, people of India gave this constitution to ourselves, an instrument of governance. So therefore, Keshwananda Bharati, by introducing basic feature, was the first principle by which the court thought that how it will be able to protect the constitution and the democracy. Then there are some other principles which are, I'm not going into the aspects, that there are hundreds of judgments, various judgments by which when a particular law is made, it is challenged, and how it is set aside or declared unconstitutional and invalid by the Supreme Court. But I'm only telling some of the principles which are evolved while deciding all these cases, which can be treated as subsets of the constitutionalism. So first is basic feature. Then we have, as far as election law is concerned, because once we talk of liberal democracy, we talk of elections, and I have said that elections have to be free and fair elections. This is also very, very necessary. If the elections are not free and fair, and the persons who are elected get elected by wrongful means, then the very essence of democracy goes. So therefore, there are, you know, that there are various judgments which are given by the Supreme Court for reforming the electoral process, which is the judgments on that that you declare your assets. Then the judgments are also on this aspect that those who are criminal and with criminal background, etc., normally, because there is no law debarring them. But then it was stated by the Supreme Court that the Prime Minister is supposed to see that they don't become ministers, etc. So there are series of judgments on this. The reforming of electoral process, the second thing. Third is expansion of Article 21, which I generally want to mention. Now, Article 21 says right to life and liberty. And it is one line article which says no person shall be deprived of his life and liberty except by process of law. Now, as far as process of law is concerned, it is now read as due process of law. In 1950, it was not so, but that judgment is overruled, and it is now read as due process of law over a period of time. But another important thing which I am saying is that the Supreme Court interpreted right to life. Right to life means right to live the life with dignity. It should not be a life of an animal existence. And under this phrase, at least if you read Article 21 and judgments, at least 40 rights are created. 38 to 40 rights are created. Right to fair wages also, right, even to the extent of going right to sleep is today our fundamental right. So these 40 rights are created in different forms. So the way it is expanded, as I said, for want of time, I'm only talking constitutional on all these aspects. There can be a complete separate lecture. So if somebody has to give lecture on Article 21, there can be a complete lecture. But another aspect which is important is that the concept of dignity, which is developed by the Supreme Court. Now, dignity is a word. Dignity is not a fundamental right anywhere in the chapter relating to fundamental right part 3. Dignity is used only at one place, that too in preamble. But then if you read various judgments, including interpretation of Article 21, where they say right to live life with dignity, and the way dignity has been expanded. Today, if I tell you, most of the rights which you will find, which are not directly under the fundamental rights, are based on dignity. When we have to give the rights to the women, equality is one thing, but then it is based on dignity. The rights given to disabled persons, fundamental rights I'm talking. Disability Act is there which gives rights, but putting at the pedestal of fundamental right, they're all judgments on these aspects, if I say so. Dignity again is one concept on which there can be a complete discourse or this. Okay, I have written one article I'll share with Mr. Chattar. He can give it to all on how dignity has become a tool. Yes, how dignity has become a tool for advancing human rights. I have written that article on given various judgments. But what I am saying is that this is again another thing which is taken. Another tool which is adopted by is institutional integrity. In various judgments, how the appointments, particularly to constitutional offices, whether it is or UPSC chairman, whether it is chairman or the election commissioner, chief election commissioner, or whether it is CBI director, etc., has to be made at the institutional integrity. And more importantly, in recent these times, in last few years, we have developed, our Supreme Court has developed the concept of constitutional morality. Now, constitutional morality, if you see, is nothing, and on this various judgments have come. We call it, again, there can be a complete lecture on constitutional morality. While interpreting the Constitution, there is what concept one says, we call it silences of the Constitution. That sometimes the Constitution is not expressly say so, but silently it is saying so. And it deduced from the morality of the Constitution. Inner morality, I said, Article 21, how it is expanded, although it is not stated there, but the court has read into that. So this is what is called now constitutional morality, and the concept which is developed again. And on that, of course, we'll say, and as I said, Keshwananda Bharati was the first case, which, although not said in so many terms, but that is based on basic features, is based on constitutional morality again. Whether you call it constitutional morality, you call it silences of the Constitution, or you call it the basic features of the Constitution, they almost derive to the same thing. But there's a subtle difference in the concepts. And again, not much time to explain those, but you read some of the recent judgments which were given by Justice Deepak Mishra. First, after Keshwananda Bharati, in Manoj Narula case, which is a constitution bench judgment, he developed the concept of constitutional morality, which he expanded much more in another constitution bench judgment, Government of NCT versus Union of India, where Delhi government status was there. If you read that judgment, he explains how the constitutional morality can be looked into. If you want one or two lines of that constitutional morality, just to understand what it means, what he says in the Manoj Narula case, the constitution can live and grow on the bedrock of constitutional morality. The principle of constitutional morality basically means to bow to the norms of the constitution and not to act in a manner which would become violative of the rule of law or reflectable of action in an arbitrary manner. So if you see norms of the talking of constitutionalism, so it is in another way of describing what the constitutional morality is. But when we use the expression constitutional morality, in a way, we are telling those who govern, with all the three branches, I will include judiciary also, that you act within the basic concepts of morality within that, and which is enshrined in our constitution. And you have to remain within the realm of that. Is why it says against arbitrary power, it should not be against rule of law, etc. And another, and this doctrine which is developed and which I'll come to in this, which would be last at least today, as doctrine of proportionality. Now, what is this doctrine of proportionality? Sometimes, and you know, fundamental rights are given. We have right to speech. Now, right to speech, I said that if somebody is speaking, whether it may be, but then there are right to speak is not unlimited or untrammeled. Article 19(1)(a) says right to speech, but Article 19 sub-article 2 says that the right to speech can be limited under certain circumstances in the interest of the state, or it should not be. The right to speech doesn't mean that I can start abusing somebody, so I can't. It should not be defamatory, etc. Should not be seditious. So all these things are there. But then, question is, the doctrine of proportionality, what it says, there may be under these articles 19 sub article 2 to article 6, the limitations, reasonable restrictions can be imposed on these, but whether they are reasonable or not. So government or the parliament can say, we have passed this legislation today to curb article 19(1)(a) under certain circumstances which are reasonable. How to test this reasoning? A doctrine of proportionality comes. The Supreme Court has said that, look, it should be proportional to the need. And I will only tell you what are the, and you will understand that from there, what are the criteria to be used in going by the concept of proportionality, how the courts deal with this issue. First thing, the question would be, when the petitioner comes, whether petitioner is claiming a right, whether that constitutional right is there. Of course, right to privacy, right to freedom of speech is a clear right given under that. But say in the context of privacy, whether right to privacy is a fundamental right or not, privacy is mentioned. So it led to a long debate, and ultimately various types of cases ultimately settled in Puttaswamy case by 9-judge judgment that right to privacy is also a fundamental right. And it is not only a facet of Article 21, it's a combination of 14, 19 and 21. So that is the interpretation. So first, when the person comes and he say that my right to privacy is violated, the court will look into whether it is fundamental right or not, which in Puttaswamy case, the court held, yes, it is a fundamental right. Now, once it is said fundamental right, now violated is by some action. The second question would be that some action which is putting limitation on this right. So the second question is that inquiry whether it is putting a limitation, whether that action. If it is yes, then the third inquiry is that because Article 19(2) to 6, they all say it should be backed by law. It should not be an administrative action or executive action. So whether it's a law passed to check that. If there's no law, the action is set aside. So that will be the third. And the fourth is this, which I say, proportionality. You are restricting the right of a person, whether it is proportional to the needs. Here again, this proportionality, when it comes, again the inquiry is in this form, if I tell you, and it is all stated in the judgments. First judgment in which it was doctrine of proportionality was elaborated is that NEET case where the NEET examination, it is, I'll tell you the name of the case, Modern Dental College and Research Center case of 2016-7 SCC 353. I can take pride in that Constitution Bench judgment which I wrote. I developed this doctrine of proportionality. And what was said laid down, which is ultimately then accepted in Puttaswamy case 1, and then followed in Puttaswamy 2 in Aadhaar judgment also, which I authored. But 4 things when we state the doctrine of proportionality. Number 1, whether the purpose is a proper purpose. It should be a proper purpose. Then number 2, whether the action taken is rationally connected with the fulfillment of that purpose. If you remember under Article 14, when we talk of reasonable classification, test is that this reasonable classification is based on a rational which has the objective, which is the connection with the objective sought to be achieved. So same type of thing, that whether the purpose which is stated, this restriction is connected with the fulfillment of that purpose. Third is the measure undertaken are necessary in the sense that no other alternative possible, because we are limiting the fundamental right of a person, that no other alternative was possible, and that was the only alternative possible. This kind of limitation was possible. Take for example today, if I explain COVID-19 situation. Today and the lockdown, the government has said under the Disaster Management Act, lockdown is there, the law is there, that you will not come out of the houses. It infringes my, I have a right under Article 19(1)(c), right to move around freely. So that it's an restriction on that right. The question is, but such a restriction can be, if you see the Constitution, in public health, they're public. So it is a situation of public health. So therefore, nobody has even challenged this till date. Everybody, we are all agreeing. Yes, we know it is so obvious, but then there is no other possible today way. And when the possible ways are coming, relaxations are given by the court from time to time. And on that, the fourth comes, that is balancing. That it is given to the extent that that is possible, that is feasible, and it should not go beyond that what is not feasible. So all these aspects are, and therefore, if you know, if I say in nutshell, in Aadhaar judgment, although Aadhaar as such, the Aadhaar identification was upheld, but many provisions in the Aadhaar of linkage with the bank accounts and others, they were set aside. So Aadhaar, where the benefit is given to, that was the purpose under section 4, if you see, that it is given to the poor persons, the welfare bed schemes which are floated by the government, so that directly money can go there in their bank accounts on the basis of Aadhaar, that it is not going to anybody else. And as we know that even Rajiv Gandhi, when he was the Prime Minister, said that 1 rupee which is spent by the government for welfare of the people, exact amount which goes to the pocket of the person is only 15 paisa. 85 paisa is frittered away by the intermediary in between. So therefore, entire money goes, and if that is the purpose of Aadhaar, then naturally that is a legitimate restrictions on privacy. But as far as banking accounts, etc. are concerned, we and many other 4 or 5 provisions, we said that these provisions, they do not meet the test of proportionality. You are trying to violate the privacy, but this you can achieve by other means also. Aadhaar is not the only mean possible for this, feasible for this. which can be achieved by other means. Bank account, if I have to open, I can go with my passport, I can go with my ration card and open it. Why you need only Aadhaar for that? So that is possible. So that is how the doctrine of proportionality is again said. So this is, I would say, by this, at the end, I may say, the judiciary, the trust, judiciary thrives on trust of the people. Judiciary neither has sword nor the purse. That is very, and it is known as, among three pillars of the state, I have said, technically the weakest branch. Because it does not have sword or the purse. It doesn't have, that means if we have to run the institution of judiciary, we have to seek the money from the government, finance. Without that, and sword, it is not there. If our judgments have to be implemented, if somebody is given, say, tried for a criminal case for murder and given life sentence, jails are not managed by the judiciary and they will put. For that, they have to depend on the executive. So that is a sword, which carries the sword also. But it is the trust of the people which keeps it going. It is the trust of the people, and this trust is given again on the basis of social contract theory. I come back to Thomas Hobbes again. And therefore, in order to have that trust maintained, in order to have that faith maintained, judiciary at all times has to act fearlessly, independently, and not to be influenced by the other two branches at any time. It is said in separation of powers, as I said, that it is a long discourse which can be given on that. But then for good democracy or democratic system, for good polity, it is necessary that there should be a tension, but healthy tension, if word is used, between the three institutions, so that checks and balances are there. It should not be an unhealthy tension, but healthy tension is needed, as judiciary has to remain independent. So this is whatever I could summarize in this period, my concept of constitutionalism. Thank you.
So thank you. We had a wonderful session. It couldn't have been a more crisp topic, such a vast subject, but you have brought it in a very nice manner. And I'm quite happy that time and again you said that it cannot be done in a one session. Taking cue from that, we would request you that you will have to come on this platform again. I will request separately also on this platform. And
I can take some of these features separately, like dignity, like proportionality, like all that. Of course, whenever you say that.
Sir, it would be a pleasure. I'll separately, after this session, I will take the time and the topic. And I would like to share that this is around our 28th webinar. And today we had the highest participation in this chat. It shows the volume of your popularity amongst the students, the lawyers, and the people who look into the constitution in different perspectives. And more interesting facet is that we have also gone live on Facebook. So the fact that on the participations is the highest in all the webinars. We are also live on Facebook. Though unfortunately some people misuse the chat box, the entire team will look into that affairs subsequently.
It happens, no, I don't mind.
No, they say it is better to fail. It is better to fail. That it is better to try and fail rather than fail without trying.
Yes.
So Q&A sessions we are not having, but as a normal practice in this webinars, as I had discussed to you when the team had invited you. So we would like that you have a vast experience. You were an established lawyer as a judge, chief justice, and the Supreme Court. Your judgments have taken an entirely different trajectory. People follow that. That is taken into the books of students. It is followed in the subsequent judgments. But before that, we would just like to know what, according to you, makes a person a good lawyer and a good human being. What should one do to make a mark as a lawyer within the profession? Because as you are well aware that there is a lot of competition. How can one carve his own niche amongst the clients, amongst the people? How can he come out? How can he actually show the Darwin theory, survival of the fittest? What should he do?
You yourself, you have answered also in your questions were the implicit answers as well. You talk about that survival of the fittest. So therefore, the person has to be a good lawyer. has to acquire all those attributes or qualities of a good lawyer to become that fit. And which is, if you see, I would say that lawyering, and when we talk of litigation, because we are not talking of corporate lawyers and others, we are talking of litigation, a person litigating lawyer in a court. What is needed? Knowledge of law in a particular branch, whichever branch one is practicing. And unless I have a knowledge of law, robust knowledge of law, how will draft any pleadings? Because I should understand if I'm asking for a particular right, it may be a civil suit, a plaint, where suppose I'm asking for specific relief, filing a suit for specific relief. I should understand and know the nuances of specific relief act under a specific performance. So under specific relief act, that what are the circumstances under which specific performance would be given, what are the circumstances under which it can be denied, so that I take care of those things. So first is that there should be good knowledge of law, and law, both substantive law as well as procedure law. Because substantive law, yes, I file the petition on the basis, even if it is a writ petition, I draft the writ petition and argue on the basis of law. But then the procedure law in civil cases, particularly or criminal cases, where the trial, etc., has to take, unless I know the civil procedure or criminal procedure or the evidence act, etc., I may have a good case, but I may still, I'm not bringing the relevant evidence before the court in order to prove my case. So therefore, knowledge of law is necessary. Second thing I say is that the knowledge, as your writing powers should be good. The prowess, writing prowess, because when you draft the pleadings, particularly it is of if it is a suit or plaint which is filed, we know under CPC what is to be stated, what is not to be stated. But then it should be like we can't state the law there. We can't state the evidence, etc. We have to just state the facts in brief, because all that would be a matter of evidence. But more so in appeals and in writ petitions, where as far as writ petitions are concerned, I would say, and I have seen, and you also know as lawyers, it is not necessary even that notice will be issued. It can be dismissed on the very first hearing. And as in appeal, the court is convinced that there is nothing in this appeal, apart from, I'm not talking of first appeal under section 96, which is on facts as well as law. It has to be admitted and ultimately, not necessarily admitted, but then the court is bound to call for the record and then decide. But in second appeal, where suppose there is no question of law, as per the court can dismiss, we call it dismissal in limine. Writ petition also dismissal in limine. But then many times, from my experience, and you people also, lawyers, have observed, and I can say as a judge, many times when a particular petition comes before the court, lawyer doesn't have to even open his mouth. And the court is convinced after going through the petition, whether it is appeal or a writ petition, etc., that a very good case is made out, and it is said, yes, notice, stay, etc., whatever is demanded. So that is on the basis of the quality of the pleadings, which would be again another part when we ultimately argue the case and file written submissions, etc., the quality of those written submissions. So therefore, knowledge of law, then writing, quality in good writing, expressing, and third, expressing the same thing by means of oral arguments, because oral arguments also have a very qualitative value in the court. I give you one simple example I still remember, and what I'm saying is that you argue law in the court, no problem. You argue the various facets of law. You have since you are well versed in law, you may quote those judgments, etc. also. But here I am talking of oratory skills. Sometimes sheer oratory skills carry the day. I remember, I'm telling you, when I was a young lawyer, and we had engaged in one case, Dr. L.M. Singhvi, Senior Singhvi, Dr. Abhishek Singhvi's father. And it was a case where our client, she was manager of a school. She was given the house accommodation in the school, and they had the management also, but some people had usurped that management, and we had filed the suit seeking declaration and seeking injunction, etc. It was filed in Delhi High Court. What happened, she was an old lady, I think at that time even 76, 77 years old. And one day, I'm only talking of one of the facet, not of the case on merits, but she was not allowed to take her car inside the school to go to her house, which was inside the premises. They said, sorry, it disturbs the students. We are not allowing you. And we had to take that permission, file an application, taking this permission or restraining under Order 39, Rule 1 and 2, that they should not interfere in our moving up to my house. And I still remember even today one sentence which gave us the order, and that is the oratory skills. One could have argued on merit so many things, my house is there inside, easement rights and all that. Those, yes, those are there, which we had stated all that, and how I enjoy. But the other side was saying, look, we are not saying that you don't go, but we are saying the students are getting disturbed, and therefore you can't take your car inside. And Dr. Singhvi said one sentence. We had given the document showing that she is a heart patient, a 76, 77 years old lady who is a heart patient. He said, my lord, the other side is saying only 150 yards she has to walk. But these 150 yards, if she walks, may be journey to her death. This may be walking to her death for a person who is 77 years old and is suffering from this heart ailment, serious heart ailment. And immediately injunction was given. So therefore, I'm only saying the oratory skills many times matter when you have to, and all of you must have seen. So therefore, for a good lawyer, first of all three attributes have to be there. Then I would say, ultimately, one can take mileage, or one can take, say, in short run, some advantages by playing smart with the court. But ultimately, it is the honesty and ethical values which every lawyer should practice, which would make him or her a great lawyer. You may earn money, but you will not be able to earn the respect, neither of the judges nor of the your even companions also. Let me tell you very frankly, now again I am as a judge disclosing one thing. When you come out of the court of any judge, and when even you are sitting in your cafeteria in the high court premises, you discuss about judges, such and such judges, this way, I mean, his good qualities, his bad or her bad qualities, etc., which is normal. But what I am telling you is, even judges discuss about lawyers. So therefore, such and such lawyer is this lawyer is truthful. Now, what happens? An image is earned by a lawyer over a period of time. Now, one lawyer is arguing in the court and he says, these are the facts. He's telling or she is telling orally. If that lawyer has built that image that she is an honest lawyer, and I know that, I will not even look into the file. And whatever she is saying about the facts, I will accept that. But if a lawyer is one, he has got the, and the judiciary has got that kind of impression about him or her, that he tries to play smart, he tries to twist the facts, he tries to distort it. Whatever he has said, I'll double check it after reading the files. Yes, whatever he's saying is correct or not. I'll ask the other side, You be very well prepared and tell me whatever he's saying is right or wrong. So at the end of the day, this honesty prevails. And another thing which goes with it is that, after all, at the end of the day, justice is discretionary also. There are so many stages of a case where the judge exercises his or her discretion. Of course, this discretion is exercised on the basis of some fundamental principles, not in an arbitrary manner. But when it is a case where it is supposed today ex parte injunction I should give or not, if the lawyer enjoys a good reputation and if he or she has 50-50 case, still I will go in favor. If he doesn't enjoy that kind of reputation, I will not grant that injunction at that stage. I'll see. After all, ultimately, judges are supposed to do justice. If a particular person, he may be devious, he may have got bad reputation, if he has a good case, the relief has to be granted, because relief is not to be given to the that advocate. It is given to that party for whom the advocate is appearing, and our duty is to do justice to that party. But all said and done, when the discretionary relief and other things are come, even when, say, discretion in the matter of imposing cost, in the matter of adjourning the matters, giving adjournments. So all these, and when the commissions are given, so persons is appointed local commissioner, court commissioner for, so all these benefits go to that person. So therefore, I would say in nutshell that these three things, which are the attributes of a good lawyer, plus his ethical values. And at the end of the day, a good advocate will acquire these qualities only when he's hardworking. I remember one of the lawyers told, when I was a very young advocate, he said that it is not the years you have put in profession which makes you a good advocate. A person may have put 20 years, but not necessarily in that 20 years he has become mature. But what he said, it is the number of hours and minutes which you have put in that profession during those years that makes you good. That means hard work. In a 20 years, one person may have worked only for 2 hours a day. Other may have worked in 10 years for 15 hours a day. So that advocate with 10 years may be much more qualified, much more experienced, and much more, with all those dexterity and all those good qualities than a person of 20 years. So at the end of the day, it is hard work which plays. So hard work coupled with honesty would take you long.
So thank you. Another question. Since we are not having Q&A, we are just taking a time. We are all feeling that it's the lockdown period, and we are actually logged into a very session which is very intruding and knowledgeful. So one question which bothers in the minds of the lawyers and the students, like their judgments and the paper books, which are running into hundreds and thousands of pages. So the time is short. Everybody has 24 hours. He has to settle everything. Then how do we actually go about it? How to understand the nitty-gritty of that paper book of 500 pages or a judgment, how to come up for a crux, because the next day that has to be argued and we have to tell the real facts. How to come to the main bullet points?
No, you see, it all depends again, the court where you are. Court means level of courts, I am saying. If it is a court of first jurisdiction, it may be a district court, or even if it is high court, it's a writ petition before single judge, and first time you are arguing. Of course, at that time, full liberty is given to argue the entire case. It is the first court of first instance. But when it is a second court, appellate court, division bench, again LPA, etc. is there, or if it is third final court like Supreme Court, the you see mechanics of the the games change. There's already a judgment before division bench. In LPA there's already, or in civil case also, it is first appeal or second appeal, RSA under section 100, there are already two judgments. So therefore, of course, with these judgments, the judgment itself may be in, we don't know, it may be 5-10 pages or it may be hundreds of pages. And there are other records as well. So therefore, it is your, you have to see. And again, that comes by experience, and everybody knows that, and there are two stages. One is admission stage, one is final stage. So at admission stage particularly, when the time allotted to you to argue the case is very less, and the court has to form a view whether to admit the case or not at that stage, appeal or SLP, etc. Then at that stage, it is for you to see what is the point. If there are two basic points, it is easy. But then there may be so many points in a case, and you may have framed so many questions of law. But then you have to see it is which question which hits the nail on the head. And it is your skill to find out that, and then say that point in the first instance, which may carry the day. So that is which comes over a period of time, and all of you know, and your senior lawyers can brief you better on this. Like we judges, in say whether it is High Court, when there are 40-50 cases listed every day for admission, or it is Supreme Court, then 40-50 cases listed every Monday and Friday for admission, and you have to read these thick files. Not that, let me tell you very frankly, if it is file of 300 or 400 pages, not that we have to read 300 pages of each case. We don't read that. We can't. It would be impossible. But then over a period of time, we acquire that kind of skill, that after reading two things, number one, the judgment, which is challenged, and number two, this synopsis in the beginning as to what is attacked, what is the prime attack, we come to know whether there is any force in that or not. So likewise, a lawyer also, of course, preparation of lawyer has to be much more than that of a judge, because we are not to argue the case. Ultimately, when we read at home, and then when the case comes, just to save time, we read at home. Otherwise, we hear the lawyer and then find out whether there is any, because we may have missed something. And the lawyer says, I may have an impression that there is nothing in the case, but lawyer may then at that time tell me something which I had missed, and I said, yeah, this is a point which is worth consideration. But likewise, since the lawyers tell this to the court, it is for the lawyers to acquire these skills as to what is that point which needs to be hammered in the beginning. And yes, when it comes to final arguments, you have at leisure, you can develop your arguments on each aspects. But according to me, what I would say, that one should, before going to the court, mentally, not only mentally, even on paper, should structure his case or her case, that this is the judgment, on these grounds I am attacking, these are the propositions A, B, C, D, and on these propositions, these are the judgments. So on proposition A, I'll state these facts which are there, relevant, either pick up from my documents or from the judgment, and then I'll say how the judge has gone wrong, and these are the judgments. Or I have to defend the judgment, then task is little easier. So these are the aspects which have to be kept in mind.
After hearing you, I'm reminded, I will just quote in Hindi. In Mahabharata, they asked Bhim, andhera hai aur tu roti kaise kha raha hai? So he said, Abhyas, Arjun, Abhyas. So according to you, it is only that we have to practice and practice. The more we practice, the more it better becomes. And another point well taken from you is, as you have said, that the greatness of great men is not achieved in sudden flight, but it is achieved while others were sleeping. He was working day and night. So it was a wonderful session. I have a pleasure. Anu Chatrat being my sister also, and she's the dean of the law department and the senior advocate. I will just call upon her to propose a vote of thanks on behalf of BeyondLawCLC as well as ULS Punjab University, being a dean in that capacity. Over to Anu. Anu, Sapan, check it out.
Good evening, sir.
Good evening.
Our distinguished faculty members, all participants, and young practicing advocates. It's a great opportunity for me and a privilege to propose a vote of thanks, being a Dean of Law Faculty, because it's a joint effort by for holding this webinar jointly by the Punjab University,
But
UL.
I have seen you in courts.
So she's a dean otherwise, but she's the senior advocate.
I am a senior
That's
advocate.
what I'm saying. When I was Chief Justice, I've seen you.
Yes, sir.
Once you thought, sir, with your father also.
Yes, sir. She's donning both the robes very wonderfully.
Okay.
Sir, Justice Sikri, in a short time, due to paucity of time, he has tried his best to highlight and explain in a simple language the foundation of the theory of social contract, as enunciated by renowned philosophers like Hobbes. He also explained the role of constitution in the present framework of governance of India under a democratic framework wherein the pillars of the state, that is the legislature, executive and judiciary, have been assigned specified roles with the sovereignty residing in the people of India. But I have noticed one thing, that because the topic selected for today's webinars is such a vast topic that this limited time is, we can't do justice with the topic. So I would request Professor Ratan Singh, and being a dean, we would be requesting you, sir, to come in the ULS and address our students, because it is such a topic we can cover and we can spend the whole day. And you have, though in a limited time, you have tried to do justice with the assignment, but we will be requiring more time. First of all, I would request, and I am sure that all the participants would be having a great learning experience by attending this webinar. I would like, because now everybody knows that we are facing such a global health crisis, that, and due to lockdown, we are, by holding these type of webinars, we are keeping our young advocates in active mode, so that the moment the situation improves, then we join back the profession. We are already in the active mode. So, because being a dean, I have seen ULS on each Saturday, Sunday, we hold all the seminars and like moot competitions, so that the moment the young advocates and the students, they join the profession, they are already experienced. And the first day they can appear before the judges in a very proper way. And they have the basic decorum to address the courts. So by this effort, I would like to congratulate the team of the BeyondLawCLC under the Vikas Chatrat and Sapandhir, because and Dr. Professor Ratan Singh, because he always keeps the young faculty members as well as students on an active mode in the department. So it's a joint effort, and because of this joint effort, we are trying to do some justice with our legal duties also.
Yes.
So
all the best.
Thank you very much, and especially I convey my thanks to the participants, because without their presence, I believe no effort of the law department as well as BeyondLawCLC can be fruitful. Thank you, sir. Thank you.
Thank you very much. And
thank you, sir.
And thanks everybody.
Rajan Baradji also, because I have seen him.
No, Rajan Brad had to go. He had sent me a text that he had to go. Otherwise, he wanted to.
For some time, he was.
So much so, sir, we would like to share that Justice Surinder Gupta and Justice Pramod Kohli, I'm not very sure as to whether they are still on the platform. They had also participated. Mr. Dushyant Dave had promised that once Mr. Sikri is coming, but at the same time, tomorrow the Supreme Court Bar is having the farewell of the first virtual farewell of
yes, Justice Deepak Gupta. Yeah,
sir, it was a wonderful, enriching experience. And as we have already taken a promise from you that we will ask you to come again on this platform, the entire participants will spread a word that you are coming. More and more participants will come, because they know that what you told today was nothing less than the Kohinoor Hira. Thank you, sir. And those who want to stay connected to us, follow us on the Facebook page or the Instagram page, BeyondLawCLC, or connect us on the WhatsApp. Thank you. And tomorrow we are having a session of elections law by Senior Advocate and Additional Solicitor General, Mr. Satpal Jain. Join us tomorrow at 11:30. Thank you, everyone. Thank you, Vin.
Okay. Thank you.